a significant development, the Supreme Court of India today reserved its order on whether the cases filed by rival factions of the Shiv Sena party led by Uddhav Thackeray and Eknath Shinde in relation to the 2002 Maharashtra political crisis should be referred to a larger bench to reconsider Supreme Court's 2016 judgment in the case of Nabam Rebia versus Deputy Speaker. A 5-judge bench led by Chief Justice of India D.Y. Chandrachud and also comprising Justices M.R. Shah, Krishna Murari, Hema Kohli and P.S. Narasimha heard arguments on the need for reference for 3 days. In this video, we will provide you with a brief outline of arguments that were advanced during the hearings by the concerned counsels. In the case of Nabam Rebia, it was held that a speaker will be disabled from deciding disqualification petitions under the anti-defection law, that is under the 10th schedule of the Constitution, if a notice under Article 179 Clause C of the Constitution for removal is pending. The correctness of this view has been called into question in the present matter by the lawyers representing the Uddhav group. However, the stand of the Shinde group is that no such reference is required. The ratio laid down in Nabam Rebia was invoked in this case by the Shinde group to argue that the Deputy Speaker of the Maharashtra Assembly cannot proceed under the 10th schedule of the Constitution against the dissident MLAs as a notice seeking his removal is pending. To provide a bit of context for all of you into the dramatic turn of events, on June 27th last year, a vacation bench of the Supreme Court had extended its time for the Shinde camp MLAs to respond to the Deputy Speaker's notice under the 10th schedule until July 12th. However, the very next day, the governor asked the Uddhav Thackeray government to seek a trust vote on June 30th. On June 29th, the vacation bench of the Supreme Court refused to stall the trust vote. Following this, Uddhav Thackeray announced his resignation as the Chief Minister of Maharashtra. Thereafter, in August, a 3-judge bench referred 11 issues in this case to a 5-judge bench, including the correctness of Nabam Rebia. The 3-judge bench prima facie observed that the reasoning in Nabam Rebia was contradictory. Now, moving on to the arguments advanced in this case, senior advocates Kapil Sibal, Dr. Abhishek Manu Singhvi and Devdutt Kamath, representing the Uddhav side, essentially argued that Nabam Rebia decision enables defecting MLAs to stall disqualification proceedings against them by simply issuing a notice seeking Speaker's removal. On the other hand, senior advocates Hari Salve, Neeraj Kishan Kaul, Mahesh Jethmalani, Maninder Singh and Siddharth Bhatnagar appearing for the Shinde camp opposed the need for a reference. Solicitor General of India Tushar Mehta appearing for the governor also opposed the need for reference. In the rejoinder arguments that were advanced before the Supreme Court today, senior advocate Jethmalani on behalf of the Shinde group argued that the Nabam Rebia issue was merely academic in nature and did not arise in the facts of this case at all. He pointed out that the notice for resolution of Deputy Speaker's removal did not attain finality. The Chief Minister also resigned before the trust vote, so the facts of the case do not support the need for a reference. Arguments were also advanced as to from which moment will the Speaker face disability. It was the argument of the Uddhav side that a mere notice under Article 179 Clause C will not disable the Speaker. The notice has to be admitted in the House and put on vote. It is only during the voting process that the Speaker is disabled from presiding the session. However, on the contrary, the Shinde faction argued that a bar on the Speaker in entertaining the petition for disqualification must attach once a notice for intention to remove the Speaker is sent. Emphasizing that the removal notice in this case was a mischief to stall disqualification proceedings, senior advocate Kapil Sibal on behalf of the Uddhav faction argued that the notice against the Speaker was sent preempting the disqualification notice. Narrating the chronology of events, he pointed out that the notice for Deputy Speaker's removal was dated June 21st and was received by his office on June 22nd. Senior advocate Kapil Sibal further argued that the notice asked the Deputy Speaker to refrain from taking action under the 10th schedule in view of the Nabam Rebia decision. However, on that date, the disqualification notices were yet to be sent to the dissidents. They were sent only on June 23rd. Therefore, the removal notice was a mischief intended to paralyze the whole process, Sibal contended during the hearing. He denied that the issue was academic by highlighting that the June 27th order was in fact obtained by the other side by referring to the Nabam Rebia judgment. The June 27th order had catapulted the events leading to the government's fall, the senior lawyer underscored further. Sibal also argued that Nabam Rebia was giving a scope for abuse of the constitutional provisions to topple lawfully elected governments, and I quote from his arguments here, "This issue will arise time and again. Elected governments will be toppled. No democracy cannot afford it. So please don't say this is academic. I beg of you, do not allow 10th schedule to topple a government. My submission is don't allow the decision to be used to topple a legally elected government. You are disabling Speaker and toppling the government." He also emphasized that the 10th schedule does not allow a defense that the dissidents constitute a majority. The only defense is that of a merger with another party, which has not happened in this particular case. He also contended that a notice seeking Speaker's removal should specify reasons and it cannot be a mere expression of no confidence. Quoting from his arguments here, "The notice should be specific to charges because it involves a stigma. The Constitution uses the word removal. It is not a no confidence. So it is not a notice in the eye of law. This petition could not have been even filed." For more information on what transpired during the hearings that took place before the Constitution bench, you can refer to our detailed reports, the link to which has been given in the description box below. Thank you. I'm Maharashtra for LiveLaw. Keep watching LiveLaw for more such updates.